Hi, bankruptcy attorney Brian Barboza, and today I'm going to discuss what assets or what property can you keep if you were to file a Chapter 7 bankruptcy case. Before we get started, if bankruptcy is something you want to explore your options or want to talk more about, please feel free to give me a call or go to my website, barbozalaw.com, book an appointment, speak with me for free directly through the website. Okay, so if you were to file a Chapter 7 bankruptcy case, which is known as a liquidation bankruptcy, what assets can you keep? So Chapter 7 is the most commonly filed bankruptcy case. Some people refer to it as a fresh start bankruptcy because it's usually pretty quick. Generally, it's going to be 90 days long, and as long as there's no objections to your discharge at the end of the case, you automatically get a discharge of the debts that you can have discharged in a bankruptcy case. However, Chapter 7 is also a liquidation bankruptcy. And what this means is when you file Chapter 7, all of your assets that you own that day become actually property of a bankruptcy trustee. And this trustee's job, who now controls your property or your assets, is to look over what you own and determine what he or she can actually take from you and sell or turn it into its cash value and then distribute it to your creditors. Now, when a debtor who files bankruptcy is allowed to protect certain assets, and we call this called exempting assets. So you're going to be provided with exemptions to use. Now, I'm a California licensed attorney, and every state has its own set of exemptions, or some states use what are called federal exemptions. So this video is really geared towards people who are in California and who are filing bankruptcy in California. Okay, and so with that caveat, when someone in California files a Chapter 7 bankruptcy case, they're going to be allowed to use one of two different exemptions. And also, there's a little trap here. You have to live in a state at least for 2 years prior to the bankruptcy being filed to use that state's exemptions. Okay, so there's kind of a little trap you got to be careful of, because if you moved from some state that has really bad exemptions or real low amounts of exemptions, and then you file bankruptcy in California too soon, you might be stuck with those other states' exemptions, and that might not be very beneficial. So watch out for that trap. Okay, so if you were in California for 2 or more years consecutively prior to filing bankruptcy, you're going to use California exemptions. There's going to be one of 2 exemption schemes you can use. Now, one of the schemes allows you to protect home equity. So if you own a home and it has equity, you know that's going to be an exemption category or scheme you're going to want to use. Now, the issue with that category is it gives you up to around, at least in our region, around $600,000 of home equity that you can protect in a bankruptcy case, which means if your home has $600,000 of equity or less, the trustee is not going to sell it, because the first 600 grand is yours, so it doesn't go to the bankruptcy estate, so there's no reason for the trustee to sell the house. The problem with that exemption scheme is it doesn't give you a lot of personal property protection, so that can be problematic. So if you have multiple vehicles, or you have a significant amount of money in savings or in brokerage accounts, stocks, maybe motorcycles, high-end jewelry potentially, those other kind of assets could then be liquidated and the money paid over to your creditors. The other exemption scheme doesn't have a homestead exemption, but it gives you a lot more personal property protection. It has what's called a wild card exemption built into it, where not only are there exemptions for specific things like vehicles and whatnot, but you're going to be given about I think it's like $33,000 right now that you can use towards any other kind of property you want to protect. So that gives you a lot more exemptions or protections for personal property. So number one, you're going to figure out which scheme helps you the most. Okay, then you have to stick with it. And as I mentioned, there are certain assets that are specifically exempted, but only up to a certain dollar amount. For instance, a vehicle may only have an exemption amount up to $7,500. So if your vehicle is worth, let's say, 20 grand, and you don't have a car loan on it, and you're only going to be able to protect the first $7,500, then the trustee is going to take that car, sell it, give you a check for $7,500, and then give the rest to your creditors. So there are some exemptions that are potentially fully exempt, like let's say retirement accounts, 401ks could be fully exempt, but there are other assets like vehicles that are only going to be partially exempt, let's say $7,500. And you're only going to be given a $7,500 exemption for total. So if you have multiple vehicles and they don't have loans on them, there's a lot of equity, then those additional vehicles could be sold, or boats, RVs, motorcycles, and other personal property can be sold by trustees. So exemptions can be very complicated, and you're going to really need a professional to look over your estate to determine what assets can and cannot be exempted. So before you file the bankruptcy, you have at least a forecast of what you're going to be able to keep and what you're not going to be able to keep. Now, oftentimes cases are what we call no asset cases because everything is in fact exempt. Or there might be a little bit of equity in certain things, but it's just not enough for the trustee to want to mess around with. So the trustee doesn't sell those assets because it will not result in a meaningful distribution to your creditors. So exemptions are complicated, as I mentioned, and you really should have a professional take a look at your estate and determine what is or is not exempt. And also, sometimes you can negotiate with a trustee if there is, let's say, a vehicle that the trustee may want to sell. Your attorney could perhaps negotiate where you buy the equity from the trustee at a discount, because then the trustee doesn't have to hire a broker or an auctioneer or an attorney to deal with the sale. You can just do a sale with the trustee for a discount rate. So there's also some other things you can do within the confines of a bankruptcy case. The converse side of that is if you are just concerned that you're going to lose your assets because the exemptions don't fully protect all of your assets, you could do what's called a Chapter 13 bankruptcy, which is a plan of reorganization, which is a 3 to 5 year repayment plan. And the nice thing about Chapter 13 is it's not a liquidation. You're not going to lose your property. The trustee in that case is not looking to sell your property. Now, the value of your property does matter because that could determine what your payments need to be. But Chapter 13, you're not going to lose your assets because it's not a liquidation. The trade-off is you're going to make a monthly payment to a trustee for 36 to 60 months. The trustee takes the check, sends it out to your creditors. At the end of your Chapter 13 plan payments, whatever debt hasn't been paid, as long as it's a dischargeable type of debt, would be discharged. So if you're really concerned about losing assets in a Chapter 7 because the exemptions aren't fully protecting all of your property, then maybe you look to do a Chapter 13 to protect those assets from liquidation. So there's some other alternatives you can have baked into what kind of bankruptcy you file. That's it. Again, I could give a 2-hour talk on what exemptions are. They're very complicated, and it's statutory based with a lot of case law interpreting it. So it's not something that's easily understandable. If bankruptcy is something you want to talk more about or you want to explore your options, feel free to give me a call or go to my website, barbozalaw.com. Book an appointment to speak with me for free directly through the website. Okay, as always, thanks for watching this video. I hope it was helpful, and have a good rest of your day. Take care. Bye.